You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The U.S. privacy and security regulatory ecosystem is decentralized, with multiple federal agencies exercising overlapping authority. Unlike a single comprehensive regulator model, the United States divides oversight across agencies with distinct statutory mandates. This arrangement creates both flexibility and complexity, as organizations must navigate different standards, enforcement priorities, and remedies depending on the context of data collection and use. The Federal Trade Commission plays a leading role in consumer privacy enforcement, while the Federal Communications Commission focuses on telecommunications. The Department of Commerce coordinates international data transfer frameworks, and the Department of Health and Human Services enforces health privacy laws. Financial regulators add another layer for institutions handling sensitive financial information. For exam candidates, the key is recognizing the mandates of each agency and understanding how their authority intersects. This knowledge provides the framework for analyzing compliance obligations across industries and anticipating enforcement risk in a fragmented environment. The Federal Trade Commission is the most prominent federal privacy regulator, with authority under Section 5 of the FTC Act to prohibit unfair or deceptive acts and practices. In privacy and security contexts, this means the FTC can bring actions against organizations that misrepresent their data practices or fail to implement reasonable safeguards. The agency has defined unfairness as conduct causing substantial consumer injury not outweighed by benefits and deception as misleading statements or omissions likely to affect consumer decisions. For exam purposes, candidates should remember that FTC enforcement often arises from privacy notices, data security failures, or misleading consent practices. The FTC's broad jurisdiction makes it the de facto federal privacy watchdog, filling gaps where no sector-specific statutes apply. Consent orders are a hallmark of FTC enforcement. When the agency finds violations, it often negotiates settlements requiring organizations to commit to multi-year compliance programs, subject to ongoing monitoring and reporting. These orders can last 20 years, embedding privacy obligations into organizational governance long after initial enforcement. Remedies may include independent audits, risk assessments, and restrictions on data practices. For exam candidates, recognizing consent orders is important because they exemplify how the FTC enforces compliance not only through penalties, but also through long-term oversight. This approach reflects the principle of accountability. Organizations must demonstrate they have built sustainable privacy and security programs, not simply pay fines and move on. The FTC also plays a central role in enforcing the Children's Online Privacy Protection Act. It has authority to promulgate rules under HIPAA and bring enforcement actions against violators. Key obligations include obtaining verifiable parental consent before collecting data from children under 13, providing clear notices, and limiting collection to necessary information. HIPAA cases often involve online platforms, app developers, or advertisers targeting children's content. For learners, HIPAA illustrates how the FTC combines statutory enforcement with rule-making authority, shaping both interpretation and compliance. Exam scenarios may test recognition of how HIPAA obligations differ from general privacy requirements, particularly regarding consent standards and parental involvement. The FTC's remedies include both injunctive and monetary components. While Section 5 itself does not authorize civil penalties, other statutes do, and the FTC can seek penalties when violations occur under rules like HIPAA. Civil penalties may reach millions of dollars, alongside restitution and disgorgement. More importantly, FTC orders often reshape industry practices, as settlements signal expectations for what constitutes reasonable security or fair data use. For exam candidates, remembering that FTC remedies extend beyond penalties to long-term programmatic changes is critical. Enforcement is as much about shaping norms as punishing violations, reflecting the FTC's role as both regulator and standard setter. Priority areas for FTC enforcement continue to evolve. The agency has focused on data brokers, holding them accountable for opaque data collection and resale practices. It has also emphasized biometric information, scrutinizing facial recognition and fingerprinting for risks of misuse. Artificial intelligence is another emerging priority, with the FTC warning against biased algorithms, lack of transparency, and deceptive claims about AI systems. For learners, understanding these priorities is important because exam scenarios may reference contemporary enforcement trends. This reinforces the need to view the FTC not as a static enforcer, but as an adaptive regulator, responding to new technologies and risks in the data economy. The Federal Communications Commission's authority stems from the Communications Act of 1934, making it the primary regulator for telecommunications privacy. The FCC governs customer proprietary network information, requiring carriers to protect call records, billing details, and service usage data. This ensures that carriers do not exploit or disclose sensitive telecommunications information without proper safeguards. For exam purposes, the key term is CPNI, which represents the specific privacy category the FCC protects. Understanding the FCC's jurisdiction helps distinguish its narrower telecommunications focus from the FTC's broader consumer protection authority. Together they create overlapping but distinct enforcement landscapes. The FCC also enforces the Telephone Consumer Protection Act, regulating robocalls, autodialers, and pre-recorded messages. TCPA requires prior consent for many forms of telemarketing, with stricter rules for mobile numbers. Violations can result in substantial statutory damages, often pursued through private lawsuits. For exam candidates, the TCPA illustrates how telecommunications privacy intersects with consumer protection and litigation risk. The FCC's rules also extend to text message marketing, where consent standards remain central. Understanding these consent dynamics is essential for analyzing questions involving telecommunications marketing practices and consumer rights. Do not call registries represent another FCC enforcement area. The FCC coordinates with the FTC to manage the registry, which allows consumers to opt out of unsolicited telemarketing calls. Enforcement mechanisms include fines, forfeiture orders, and restrictions on violators. For exam candidates, recognizing this interplay highlights that consumer marketing privacy is co-regulated by both agencies. While the FTC manages the registry, the FCC enforces compliance within telecommunications carriers' jurisdiction. This overlap exemplifies the fragmented but coordinated approach of U.S. privacy regulation. The FCC also regulates the privacy of location data and emergency services. Rules require that carriers protect precise geolocation information, limiting disclosures to lawful or emergency purposes. For exam purposes, the key terms are location data and emergency services, signaling areas where privacy and safety intersect. Scenarios may test whether carriers meet obligations to safeguard location data or whether disclosures fall within exceptions. This illustrates how telecommunications privacy is tailored to specific risks, reinforcing the principle that context shapes regulatory obligations. The relationship between the FTC and FCC is defined by both overlap and divergence. Both agencies regulate consent in consumer communications, but their standards differ. The FTC may emphasize deception and fairness, while the FCC applies specific statutory rules under the TCPA or Communications Act. For exam candidates, recognizing divergent consent standards is essential. A practice lawful under one framework may still violate the other. This interplay underscores the importance of multi-regime compliance, as organizations must align practices with multiple regulators simultaneously. The FCC enforces its rules through an administrative process that can escalate from notices of apparent liability to forfeiture orders imposing fines. Organizations may challenge these actions, but the FCC retains significant authority to penalize violations. For exam purposes, recognizing administrative enforcement structures demonstrates how privacy obligations are operationalized in practice. Unlike FTC consent decrees, which focus on long-term compliance, FCC enforcement often emphasizes penalties for specific infractions, reflecting its narrower statutory mandates. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Department of Commerce plays a facilitative rather than enforcement role in privacy, particularly in the realm of international data transfers. It administers the EU-US Data Privacy Framework, which replaced the invalidated Privacy Shield and Safe Harbor agreements. Under this program, U.S. companies self-certify adherence to privacy principles recognized by the European Commission, enabling lawful transfers of EU personal data to the United States. For exam candidates, the key terms are facilitation and international transfer. Commerce's role illustrates that privacy regulation involves not only enforcement but also diplomacy and coordination, ensuring U.S. businesses can participate in global data flows. This function highlights the practical importance of frameworks that bridge differing legal systems, especially given Europe's stringent adequacy requirements for cross-border transfers. Within the Department of Commerce, the National Institute of Standards and Technology provides voluntary frameworks and guidance for managing privacy risks. The NIST Privacy Framework is modeled after its well-known cybersecurity framework, offering organizations a structured method to identify, govern, control, communicate, and protect personal information. Although not legally binding, the framework is widely used to demonstrate accountability and prepare for regulatory scrutiny. For learners, the key point is that NIST guidance often becomes a de facto baseline, incorporated into contracts or referenced by regulators as best practice. On the exam, scenarios may test whether NIST's framework provides enforceable obligations or persuasive standards, requiring candidates to distinguish between law and voluntary guidance. The Department of Commerce also convenes stakeholders to address emerging technologies, such as artificial intelligence, biometrics, and automated decision-making. This convening role allows government, industry, and civil society to shape policy collaboratively before laws are enacted. For exam purposes, the key term is convening, signaling commerce's influence in shaping policy trajectories even without enforcement authority. Candidates should understand that while commerce does not impose penalties, its initiatives often lay the groundwork for future regulation and provide practical guidance for organizations navigating uncharted technological frontiers. The Department of Health and Human Services, through its Office for Civil Rights, enforces HIPAA's privacy and security rules. OCR investigates complaints, conducts compliance reviews, and imposes penalties for violations. Remedies may include civil monetary penalties and corrective action plans requiring organizations to implement changes under federal oversight. For exam candidates, remembering OCR's enforcement role is critical, as HIPAA represents one of the most mature and heavily enforced federal privacy statutes. Scenarios may test whether HHS or another agency has authority, emphasizing the importance of matching statutes to the correct regulator. OCR's actions illustrate the regulatory expectation that privacy compliance is both substantive and demonstrable through programmatic safeguards. The HITECH Act strengthened HIPAA enforcement by adding breach notification requirements. Under these rules, covered entities and business associates must notify affected individuals, regulators, and sometimes the media when breaches of protected health information occur. OCR enforces these provisions and has pursued significant penalties against organizations that fail to notify in a timely or adequate manner. For exam purposes, the key terms are notification and enforcement dynamics. Scenarios may test whether breach response obligations have been triggered, reinforcing the principle that privacy law extends beyond prevention into transparency and remediation after incidents. Additional health-related protections include the confidentiality of substance use disorder patient records under 42 CFR Part 2. These rules impose stricter confidentiality than HIPAA, requiring explicit consent for disclosures in most cases. Enforcement ensures that sensitive treatment information is not misused, reflecting the heightened stigma and risks associated with disclosure. For exam candidates, recognizing that Part 2 imposes stricter standards than HIPAA is essential. Exam questions may test whether organizations must comply with both regimes or whether stricter rules take precedence. This illustrates how layered statutes impose different thresholds of protection depending on the sensitivity of data. In financial services, the Consumer Financial Protection Bureau exercises supervisory and enforcement authority for consumer financial privacy. The CFPB investigates practices that may constitute unfair, deceptive, or abusive acts, and it enforces specific statutes such as the Fair Credit Reporting Act. For exam candidates, the key terms are supervision and enforcement, distinguishing CFPB's proactive oversight from reactive complaint-driven models. Scenarios may test whether the CFPB or the FTC has jurisdiction, requiring candidates to match regulatory authority with the specific financial context. The CFPB's authority underscores the heavily regulated nature of financial privacy and its direct link to consumer protection. Federal banking regulators, including the Federal Reserve, the Office of the Comptroller of the Currency, and the Federal Deposit Insurance Corporation, oversee compliance in banks and financial institutions. These regulators enforce privacy obligations under GLBA and related statutes, often through supervisory examinations rather than headline-grabbing enforcement actions. Interagency guidelines require institutions to implement robust information security programs, conduct risk assessments, and safeguard customer data. For exam purposes, recognizing that banking regulators enforce privacy through oversight and supervisory guidance is essential. Scenarios may describe compliance failures discovered during examinations, testing whether candidates recognize the appropriate regulator and enforcement model. The identity theft red flags rule illustrates how functional regulators adopt privacy-related obligations. This rule requires financial institutions and creditors to establish programs to detect, prevent, and mitigate identity theft. Enforcement lies with the same banking regulators as well as other functional authorities depending on the institution type. For candidates, the key terms are detection and mitigation. Exam scenarios may test whether institutions have satisfied these programmatic requirements. This rule highlights how privacy overlaps with fraud prevention, making enforcement a shared responsibility across multiple regulators. State insurance departments add yet another enforcement layer. These departments supervise the use of personal data in underwriting and claims, ensuring that practices do not result in unfair discrimination. Their role demonstrates how privacy and fairness are intertwined, especially when sensitive health or demographic data influence coverage decisions. For exam purposes, candidates should remember that insurance departments operate at the state level, supplementing federal oversight with localized authority. Exam questions may test whether privacy disputes in the insurance sector fall under federal or state regulators, requiring nuanced analysis of jurisdiction. Memoranda of Understanding formalize interagency cooperation, enabling regulators to share information and coordinate enforcement. For example, the FTC and CFPB may collaborate under an MOU to address overlapping concerns in financial data practices. For exam candidates, the key concept is collaboration. Scenarios may test whether multiple regulators can act simultaneously and how they coordinate authority. These agreements illustrate the reality of modern enforcement. Privacy disputes often implicate multiple regulators, requiring structured cooperation to avoid duplication and gaps. Participation in the Global Privacy Enforcement Network highlights U.S. regulators' commitment to international cooperation. Through GPEN, agencies coordinate investigations and share best practices with counterparts worldwide. For exam purposes, the key terms are cross-border and cooperation. Scenarios may test whether international enforcement networks influence domestic obligations. Recognizing GPEN underscores that privacy enforcement is global, requiring U.S. organizations to consider not only domestic regulators, but also international collaboration. Finally, regulators are increasingly horizon scanning for emerging risks in artificial intelligence and automated decision-making. Agencies like the FTC, CFPB, and Commerce are actively developing policies and issuing guidance on bias, transparency, and accountability in AI systems. For exam candidates, the key concept is proactive regulation, signaling that agencies are not waiting for harms to materialize before shaping expectations. Exam questions may reference regulatory initiatives around AI, requiring learners to connect these to existing privacy principles. This illustrates how regulators anticipate rather than merely react, positioning privacy governance at the forefront of technological change. By mastering the mandates and functions of these regulatory authorities, candidates develop a clear picture of the U.S. privacy enforcement ecosystem. This understanding equips learners to analyze multi-regime compliance challenges, anticipate enforcement risks, and design governance programs that satisfy overlapping obligations. For exam preparation, recognizing agency roles and their interplay is essential for answering scenario-based questions and for building professional judgment in navigating fragmented regulatory landscapes. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.